580, Karl Rominger here on WHP 580 and, of course, WLAN 1390. And I've brought a special guest on today. I have Dr. Arnold T. Sheinvold. And, Doctor, you with me?
I'm here.
Your practice, and so people who don't know you are a Ph.D. in
clinical psychology.
Right. But your specialization these days is quite a bit in the realm of family conflict and custody issues. Is that correct?
That is correct. General forensic, but a specialty in family conflict, custody evaluation work, anything to do with dysfunctions within the family. And
I will disclose I've had the pleasure of working with you in at least a few cases. I'm aware of your work in a lot of others, particularly in the central Pennsylvania area. How far does your practice extend?
Oh, in Pennsylvania, I have cases from Allentown up to Wellsboro, out to Chambersburg. I've had cases in Maryland and West Virginia and Virginia, and over towards Philadelphia. So it's a pretty wide area.
Yeah, that is a pretty wide area. And I imagine you see all different kinds of situations, both in and out of court.
I do.
Today I want to focus just a little bit about a little bit of everything you do, but talk about the custody evaluation process, because that, for a lot of our listeners, we get a lot of phone calls about people who are engaged in custody battles. Mm-hmm. And notice I use the word battle instead of case. It depends on the mindset. We have a lot of people that have high conflict cases. We have other people who have lower conflict cases. I guess from a lawyer's standpoint, this is what we tell clients, and I'll tell you, I would say to a client quite frequently, I think you need to get a custody evaluator. You need to get an evaluation done, because a judge is just going to meet with your child for 15 minutes, if you're lucky, talk to the child for a few minutes, and then try to get some input from a few hours of listening to the two parents argue over who's a better parent, and somehow come up with a comprehensive custody plan. And I don't think a judge can do it in a hearing the same way that you can. So can you kind of help us out and tell us what it is you do to assist the court?
If we remember that in any of these cases, we're trying to figure out what's going to be in the best interests of the child. I mean, the standard in Pennsylvania and now nationwide is a best interest standard. When we talk about a custody evaluation by a psychologist, we're talking about what are the psychological best interests of the child, with respect to the relative parenting arrangements that can be put into place to his or her benefit. So the custody evaluator is attempting to gather as much information as they can through evaluative techniques and actually through investigative techniques as well to be able to answer that question or to make a recommendation to the court with respect to options as to what are the best answers to that question. And what you said is actually very consistent with what I talk with people about, and you can answer this part better than I, but if you get a full-day hearing in a custody case, which may be the exception versus the rule given how busy our courts are,
right?
That's probably about 6 hours of actual court time.
Yeah, I would think that's about correct. In an 8-hour day with the type of breaks and also just the physical limitations, people sometimes think that the court should go all day, but because of the requirement of a stenographic record, for instance, the stenographer simply cannot continue to type all afternoon.
Right. In a custody evaluation, in a comprehensive custody evaluation like one that might be done here, one that I might do, we're putting in close to 40 hours of time with the family, which, if you compare that to a 6-hour day, is more like a 7-day trial.
Right.
And although there are certainly parts of the country where you get 7-day trials, you don't hear of it very often around here. So we can get a lot more information and then, in a sense, serve as a liaison to the judge with that information. And so it allows both attorneys to get much more of the information that's pertinent to the decision-making to the judge.
And actually, I can give you a kind of interesting little legal quirk here, which is the rules of evidence say that I have to authenticate a lot of evidence that I bring to court. Hearsay is generally not admissible.
Right.
And so in order to effectively present a lot of information to a court in a child custody case, either both sides have to stipulate to the admissibility of the matters, or you can call an expert witness like yourself, a doctor, and custody evaluator, and then you're allowed under the rules of evidence as an expert witness to testify about things that aren't generally otherwise admissible but relevant in your inquiry.
Correct.
And so that's the other, I think, as a lawyer, the advantage we see sometimes in bringing someone like you onto a case is we can now bring in material that would have been very difficult to admit otherwise without agreement from the other side, or just prohibitive time-wise again. And just like you say, the court's not going to give me 3 days to drag in all different people to authenticate documents and to avoid hearsay.
Right, and that's really true. And there's obviously, like everything, there's a good and a bad side to that. When I'm allowed to report on what someone else has said to me, I'm allowed to report on it because I've relied on it in my report, but I'm not testifying to its veracity, to whether or not it's true. I'm just saying this is what I've heard and relied on it in my report. Now, obviously the judge can make that difference. I would agree that in some cases that's kind of a side door to get some hearsay testimony in. But I think for the most part it's done legitimately to really help the court get more information.
And I can tell you, that's the other thing I've told people. When you do have an adverse report, sometimes when people get a custody evaluator involved like yourself, we get a situation where we're not happy with the result. The client looks at you and goes, well, he's not recommending that I get primary custody. He thinks it should be split custody, and I don't understand. And the only avenue attack I usually tell people is, you can still have the full hearing, but great weight is usually going to be given to the expert's report. But that's exactly what you attack is, okay, well, let's look at what he relied on and what statements he took from people that we could prove are untrue, because some of your investigation isn't always to verify everything you're told.
Exactly. That's true.
And so that would be the best way, I would think, to attack it. But unfortunately, that is often not the case because I think generally, again, because of the length of time and the fact that I don't want to get back into this a little bit in the next segment here, the actual process of doing the evaluation, but because of the back and forth you do where you talk to some people and then bring them back in and go back and forth and gather information, it kind of self-verifies itself as it goes.
Well, a custody expert, a custody evaluator, has an obligation to get as much corroborating evidence or corroborating data as they possibly can. So what you're trying to do is get these different sources to give you data that converges on some sense of what the true data is. And every evaluation is going to have some data that disagrees with other data. You have neighbors who say the couple fought all the time, and then you might have a neighbor who says, well, I never saw them fight. But if you have 5 neighbors who are saying they fight all the time and one neighbor who says they didn't fight, then you have enough convergence of data. Then if you have psychological testing that says someone has an anger problem, and if you have, the children who you're interviewing saying, gosh, I hated when mom and dad fought, now you have a series of converging data that really helps you get a true picture of what's going on. And that's what's used in terms of assessing factors, and I guess we can talk about factors for custody in Pennsylvania now, but factors that are pertinent for the court in terms of making their decisions.
And those what do I want to say? Those concepts, like for instance, when 5 people say something, one person doesn't. It's kind of always the joke I've always said that if one person tells me it's going to rain, we don't know if it's going to rain. But if you hear it from 10 people, it's probably going to rain, or at least that's what the weather's reporting.
And the 11th comes in drenched, then you're
right,
sure.
And then you're sure of it.
Right.
I'm going to take a break here. We're going to go to commercial for a few minutes, but I know Dr. Sheinvold, you've said you're willing to talk to callers and answer some questions for folks. So the talk line number is 540-0580. Guys, this is your chance if you want to talk to an expert psychologist and maybe, kind of run something by in your own custody situation or how you feel, or maybe tell us a war story of an evaluation, or you always wondered why somebody said what they said or why they would do what they did in a custody evaluation. This is your chance. So 540-0580. We'll see you guys after the break. Welcome back. Karl Rominger here. I'm with Dr. Arnold Sheinvold with Riegler, Sheinvold & Associates out of Harrisburg, Pennsylvania. They have a comprehensive psychological practice, but Dr. Sheinvold is here talking about custody and custody evaluations with me today. 540-0580 if you want to get in on the conversation again. You guys know the number, 540-0580. This is your chance to, throw some custody questions at us if you're up for it. Doctor, when we took the break, we talked a little bit about just some general precepts. Tell me the process. I mean, how do you get involved in a case, and what happens?
Generally, a case comes one of two ways. It's referred from the court, either through the conciliation process or from the judge themselves. And there has been a request for an independent, neutral examination or evaluation of the custodial issues. That's actually the best way to get a referral. You could certainly have the parties stipulate to getting a custody evaluation. They've gotten together with their attorneys, and with the advice of their attorneys, have decided that a custody evaluation might help in the overall settlement process because there are certain questions that need to be answered, and perhaps if there was some reassurance around some issues or some clarification of issues that are causing some of the impasses and the conflict over parenting, if they had those answers from the evaluation, they may be able to settle the case. So that's another way it comes. In the past, it was not infrequent to have two experts involved, one who got hired by one side and one by the other side.
Right.
That's very much gone out of favor because you get what's called dueling experts who kind of neutralize each other, and it's a difficult way to do a neutral evaluation. So that's becoming less and less common. The more common process is to settle upon a single expert who really is not advocating for either side, but simply trying to determine what's going to be in the best interest of the child. So that's the way the referral is likely to come in within that mode. Once the referral comes in, then different evaluators use different processes. If you're a psychologist, you're going to have to follow the guidelines of the American Psychological Association for child custody studies or child custody evaluations. And generally that means what you can expect, and I won't put numbers on this, but you can expect that all of the parental figures are going to have extensive interviews, comprehensive interviews. And I say parental figures because it probably will include step-parents or significant others in that process to get a full picture. You're going to have interviews of the children if they're of an age that you can have a conversation with them. Generally, kids from 4 years up can be interviewed. Children younger than 4 can be seen, though, and observed and interacted with in some way. There'll be some observations made of the children with their parents, and that will be done and should be done to assess kind of the interaction skills and parenting skills that you see in them together, what their attachments are like, what the comfort is with the interactions. There will be the collection of collateral information. That could be doctor's reports, it could be hospital reports, it could be counseling reports, children and youth investigations, police information. Each case offers a different set of collaterals who might be important. It could be conversations with teachers or guidance counselors. It could be neighbors' input and information.
Does the court ever give you collateral information directly, like where a judge might write you a letter and say, here's my observations, or is that pretty rare?
The judge almost never gives you observations. I would say that's very rare, because it would be considered, first of all, the judge would be considering the case ahead of time, and it would be considered kind of ex parte, one-sided conversations with a judge. The judge would never have that conversation without both attorneys on the line. And quite honestly, one would have to wonder if the information is presented in some unusual way, there would be questions about the judge's possible bias in the case before he's heard all the evidence. So I would say that's virtually never going to happen. The only time that could possibly occur is, let's say there was an instance of domestic violence that occurred in the middle of a custody evaluation.
Okay.
You might then get a call and say, this is what's occurred. Could you also now, as part of your evaluation, assess dangerousness, impact on the child, whatever it may be?
Okay, interesting.
So I tried to give you kind of the breadth of information that we're trying to take in when we do this. Then there's a component of psychological testing. Obviously, if this is being done by a non-psychologist, you're going to see less psychological testing.
Right.
If it's being done by a psychologist, you'll probably see more.
Mm-hmm. Mm-hmm.
Almost all psychologists who are doing, and I say almost all because there have been surveys, there's national surveys on this, probably 85% of the people doing these use the Minnesota Multiphasic Personality Inventory, the MMPI-2, which is a pretty broad-based, what's called objective personality inventory, which helps screen for certain degrees of psychopathology and personality dynamics that might be going on in a case. Beyond that, there's a whole bunch of other psychological tests that might be used, but different people will use them differently.
Now, the criticism that I hear, and I don't mean it as a real criticism, but I'll hear people say, well, what psychologists really, there's nothing to that. They can't really figure out what's going on, and they really can't understand why somebody does what they do. And in my personal experience, it doesn't seem to be true. I would assume you would be similarly of the same mind, basically, that you guys have some ability to do that.
Yeah, or else I'd be a charlatan, wouldn't I? If I sat here and said, we have no ability to do that.
Right, we have no ability.
I'm doing it every day.
Right, and I think that's why when we look at those reports, again, from the lawyer's standpoint, I've seen the reports, the inventories of people's personality, but I'm always most interested in what your direct observations and demeanor of the person are and what you think it means in relationship to the case.
If you think of this whole process as hypothesis testing, almost like a scientific experiment.
Right.
So some hypothesis is raised. Mom is trying to block the kids from seeing dad, or that's one hypothesis. Or dad has never been involved in the kids' lives and doesn't understand their personalities, or something like that, or their styles. You then test that hypothesis by gathering as much data as you can. So if you do direct observations and dad doesn't know that his son is really interested in baseball and never talks to him about it, let's say. Or let's say that you get psychological testing that implies that this person has very little insight and is not very empathetic. And then you have neighbors who say they have never seen dad outside kicking a soccer ball with a kid, and the soccer coach who says, well, dad might come for the last 5 minutes of the soccer game.
Right.
That's what I mean by the convergence of data. So whereas no one piece of that data is saying much about that, because if I have a psychological test that says dad has little insight, but then I talk to dad, and he shows tremendous insight in the child, and he's been at every soccer game, and he is kicking the ball around with his kids, and all the kids love to jump on him and play and have a great time, then the psych testing is the outlier, and the other information is where the convergence is. So I've tested the hypothesis and gone the other way with it. That's what you're doing across the board with the various factors. Who's most likely to encourage contact between the child and the other parent. Mm-hmm. That's one of the major factors we have to look for in custody evaluation work. Well, again, using the same hypotheses, testing technique, you'd say mom either is or is not encouraging, and you look for the data that either supports that or not. And the same you would do for dad.
And yeah, and I can tell you, just come back to that fostering the other parent's relationship with the child, I find that to be a difficult concept sometimes for some of my parents to understand. Others seem to understand. I've said it this way. I've said that a third of the people in divorces never even talk to me about custody. I'll say, do you guys have kids? Yeah, we have kids, but we've worked it all out. And they don't seem to have any difficulty figuring out a custody scheme that's going to work amongst the family. A third of them seem to need somebody to give them a little bit of a kick, and then another third seem to be in that high conflict area where they need an order, and then they need to be told how to follow the order again and again and again. But
actually, nationally, if you look at the studies nationally, it's probably 10 to 15% of parents are in that high conflict range.
Is that where they just make up a third of our work? That's
well, that's exactly right. But because remember how many people are figuring out their own custody stuff without any input from outside professionals.
Right.
So you're right in that you're talking about of the ones who come to you, it may be a third, and a third, but nationally, it's that 10 to 15% who really use up a lot of time of the courts and of professionals like myself because they need that kind of input. They are just so caught up in the conflict and hostility of the divorce that they can't work through the custodial issues or the parenting issues very well.
And I see. So then when I try to explain to them, you have to foster the other side a relationship with the child. It's for some people, like we said, we talk about this lack of insight. It just goes right past them. They can't conceptualize that that's something they're supposed to worry about. And I always find it fascinating. And so that's what you can do differently. I can just sort of be amused by the fact that they don't seem to follow, and frustrated that they goof it up in between hearings and don't progress. And then when we come back, actually, after the next break, I want to talk to you a little bit more about, what we do with people after we've kind of decided how to do the custody situation, and talk about some co-parenting counseling and some of the tools that people can use to make things work. Because that's the more interesting question is, can we rehabilitate? And one of the questions I'm going to ask you a little later is, out of this 10 or 15% that we're talking about that are high conflict, realistically, what percentage or what cohort can we expect to ever resolve? Or do some of them just have to resolve when the kids turn 18?
Well, we can talk about that.
All right. 540-0580. I'm here with Dr. Arnold Sheinvold. By the way, doctor, if somebody wanted to get hold of you in your practice to potentially hire you for a custody evaluation or for work in some kind of family therapy, child therapy, how would they contact you guys?
Well, our phone number here is 540-1313.
Okay.
We're at 2151 Lingelstown Road in Harrisburg. They can call anytime during the week between 8 o'clock in the morning and 8 o'clock in the evening, except on Fridays. It closes at 5, and there's always secretaries and receptionists available. And
we're gonna put a link up to your website on our weekendappointment.com, as well as on romingerlaw.com and on a Facebook. So if people want to find it that way, they can as well. 540-0580. See you guys after the break. Welcome back. Karl Rominger here. Got Dr. Sheinvold on the line. He's talking to us about custody evaluations and how that works. If you're just joining us, we're now going to talk a little bit more about what we do to manage custody cases as they go forward. Doctor, was there anything else you wanted to tell me about the evaluation process that you thought people should know in particular?
Well, I guess the only thing I would add is that I mentioned it a little bit earlier. A custody evaluation, if viewed in a positive way, often it creates a huge amount of anxiety, and understandably so, because in essence, a parent is defending their abilities as a parent and often getting attacked from the other parent around those abilities, and it becomes kind of a negatively oriented event in that there are, some sort of allegations or concerns raised. On the other side of this, it really can be an educational event in which you have a professional who has a considerable amount of expertise in the area of parenting and what might or might not be best for children in certain contexts, offering up that advice for the parents to use or for the parents and their attorneys to use to facilitate really a flexible, dynamic parenting arrangement that really takes the children's needs into consideration in a much more individualized and unique way than they might get from the more blunt, cutting block of the court. So I think if one were to approach it more that way, it could be very, very helpful.
I've also seen in a few of the evaluations over the years where the evaluator is able to identify sufficiently individual issues with the parties, something that mom or dad might need to work on in their own psychological or spiritual health, and gives them a roadmap to what they need to do so that they can get back into the custody game, so to speak.
Oh, that's very true. It's very common for me in a custody evaluation to make multiple recommendations around either individual therapy that a parent could use to better understand certain aspects of their own personalities and how it affects their ability to work with their child or with their ex-spouse, or recommendations around counseling or therapy for kids who may be experiencing really difficult adaptations to their parent's situation, and that's really forcing the parent into having to take more difficult stances with their child at a really tough time. I mean, remember, we're seeing people, especially early on in this, not somebody who's 3 years down the line, but early on in a separation where these issues come up, we may be seeing parents at their worst rather than at their best. They may be enmeshed in anger over betrayals or perceived betrayals or perceived wrongs.
Mm-hmm.
Their own sense of stability has been undermined, and their sense of security is being challenged as they look at financial threats and legal threats and vocational threats in this. So it's very important that anybody working in the process, and most especially a custody evaluator, be aware of that, because given some time and some ability to just self-heal and allow time to heal it, this person may look very, very different 6 months or a year down the road.
Well, we just got and it wasn't from your office, but in a case I'm involved in, we got a report that basically, said one of the parties should take a hiatus from custody for 6 months while they work on some personal issues, and if they're successful with that, come back to the mix. That's not my client; it's the other client. I imagine that person probably, feels like, well, why would I do that? But I think that's what they were trying to say is you're having these major life issues of your own that need fixed, and dealing with the child as an additional stressor. But at the same time, you're all the bad things that are happening to you are rubbing off on this child when they're in your custody.
It's really a very difficult situation and a very complex situation, because unfortunately the court works in the moment.
Mm-hmm.
And in a very static way. So mom's going to have primary and dad's going to have partial, and here's the arrangement. Dad's going to see the kids every other weekend and Tuesday and Thursday evenings till 8 o'clock and sometime in the summer and sometime over vacations, whatever it may be. And it stops there. I mean, that is the arrangement. There's nothing that can be done in that arrangement that says in 6 months, let's see how things are going and see if we can move this forward a little bit more, because dad may have had some parent education training. And so, for example, we know from research that dads actually become better dads after they separate than during the marriage.
Right.
Because the roles that each spouse played in the marriage were based on the roles of the entire family intact. So dad may have relied on mom as the gatekeeper or as the primary nurturer or whatever, and was not as involved in things as he's going to become when he has to act as a single parent.
Right.
And that's like across the board. We see that as generally true, even though there's a changing dynamic in families now. But let's take the traditional kind of gender distinction. So we know dad is likely to become a better parent and learn more about routines and schedules and gatekeeping and appointments and all those type of things. But the court can't fashion a custody arrangement that way.
Right.
And if the parents can't communicate well and don't have ongoing communication, and if there's ongoing conflict, they don't have the mechanisms to make the adjustments, the flexible adjustments down the road as different parenting styles evolve.
Interesting.
So it's always a very complex mix that you're thrown into.
And I know, and that's what I'm going to want to talk to you a little bit about next, which is the ongoing, some of the concepts of, for instance, a co-parent counselor or co-parenting coordinator. But we do have a few callers popping up, so let's take a few of those here. Bill, you're on with Karl and Dr. Sheinvold.
You say Bill?
Yep.
Oh, yeah, this is me. Well, my wife, she currently is in a situation right now with her ex, and they're doing a parent coordinator thing. And right now he's trying to like get the parent coordinator off the case, and he does everything to try and manipulate everything. Back in a little while ago, the one daughter was living with him just for a couple of months, and then she was supposed to come back, and he held her and stuff for a long time that he wasn't supposed to. But what my question is, like, he continually, like today we get papers again, and he's contesting the parent coordinator. He contests everything. Is there any way to stop, like, having him keep doing this stuff, or it's consistent?
Do you want me to?
Well, go ahead. Go ahead.
I think the place to start, maybe for the listeners, is explain what a parenting coordinator is. Parenting coordination is a relatively new process that's entered the mix of alternative dispute resolution processes like mediation, introduced into the family courts. A parenting coordinator can be assigned to a case following the ordering of a decree, following a decree. So you get your custody order and custody plan, parenting plan out there, but there is so much conflict between the parents that they need someone who has the ability to facilitate communication between them and to make decisions in the event that they can't make those decisions. Now, the scope of the parenting coordinator's authority is often defined in the order that they get for that. But most definitely, a parenting coordinator cannot change the basic underlying custody schedule. So, if it's a shared custody schedule, the parenting coordinator can't make one of the parents primary and the other non-primary.
Right.
But what they can do is, let's say that mom's family is having a reunion on Sunday, and it's dad's weekend. And dad is saying, I don't care if you're having a reunion or not, I'm not letting the kid go. Rather than running to court and trying to get emergency petition and all the expense and all the time involved with that, they can go to the parenting coordinator who's been assigned to them, say, here is the conflict. The parenting coordinator can try to get them to agree to something different, but if they won't, the parenting coordinator can make the decision, and it will serve as an order, unless challenged in court, as to what will happen. So it's a process that is supposed to make life easier for kids when their parents especially are having difficulty making decisions together. So that's what the parenting coordinator is.
Yeah.
So
I mean, it's similar to what's going on right now.
Mm-hmm.
I mean, it's working actually, but
does he challenge the coordinator's determination a lot? Is that what's happening?
Well, he just did. Oh, yeah, he just did challenge it, and now he's like saying that she's pretty much incompetent and she's taking sides and all this stuff. And I went out and got a lawyer for this.
Well, generally defined in the order is a way to grieve the parenting coordinator. And the only way to grieve or try to get rid of a parenting coordinator is what he's apparently doing, which is go back to the judge and ask them to be removed. But that would have to be with some very apparent cause. And the causes that might cause a parenting coordinator to be removed are clear bias or some other unethical behavior.
Yeah, I mean,
short of that, probably the best thing that can happen is short of that is you have a very supportive judge of the process, meaning parenting coordination process, and that judge says, no, I'm not going to remove. Now, the judge may also have the option of then saying, I'm going to assess all costs for this to the party who grieved unfairly.
Yeah.
And the key to parenting coordination working is, number one, having a good trained parenting coordinator, and number two, having a good, strong, supportive judge who basically says, you're in this process, stay with it.
And Bill, I got to let you go because we got to go to break here.
Okay.
So I guess the answer is hopefully it continues to work. And now if they keep dragging you back to court to test this, that's exactly what I would ask the judge to do. I'd say, Judge, you need to make it clear to the other side that they need to defer to this parenting coordinator and only make noise when it seems legitimate, otherwise face some sort of financial sanction.
Okay.
Okay?
All right, thank you.
All right, got to go to break here, guys. 540-0580. We're talking with Dr. Arnold T. Sheinvold, Ph.D., on child custody issues. If you're just joining us, and Tina, when we get back, we'll let you ask your question. Welcome back. Karl Rominger here, usually answering your legal questions, but today we're joined by Dr. Arnold Sheinvold out of Harrisburg area, practices with regular Sheinvold and Associates. They have a comprehensive psychological practice there, and he's answering questions for us. Tina, what do you want to ask the doctor? Tina.
Yes. I have a question. I had recently participated in a custody evaluation, and I was told and under the impression that it took 4 to 6 months. Ours took over a year, and cost a lot of money that I foot the bill for. And my question is, and when we received the evaluation, a lot of the information was not included in the evaluation report, and I just felt that it was kind of a waste of my time. We got nowhere, and we spent a lot of money on this. I also have a couple friends who have experienced the same thing. My question is this, are we in the minority, or is this something typical?
Well, I'll field that first. In my experience, I can only think of one time where I thought a report was somehow deficient. I can tell you that with Dr. Sheinvold, at least, any report I've ever seen of his is very comprehensive, and it lists what was relied on. But generally speaking, if you had counsel and I'd been your lawyer, I would have said, okay, what is missing, what's wrong here, and let's see what we can do to feed this back to the doctor or the licensed social worker, whoever's produced this document, and see how they would respond to that. And a year does seem like a long time to get your report.
I would say the typical length of time for a custody evaluation, a comprehensive custody evaluation, and so we go back to what I was saying, our process is earlier, is probably 3 to 4 months, maybe 5. And part of there's several reasons for that, or could be several reasons for that. When you're coordinating the schedules of all the people that I was talking about, that sometimes is problematic. So, for example, I might have a parent who tells me, well, I can only come in Mondays at 7 o'clock. So, therefore, my ability to see them becomes tremendously hampered. So scheduling problems can certainly arise. If there are important records that I need to see, you're at the whim of the people sending you those records, or you have to go back to the court and ask the court to order the records released, so that can slow it down. So there are a variety of issues that can slow it down. I would say part of the reason that at a minimum it takes 2 months goes back to something I said earlier, and that is that if you condense your evaluation to just a couple of days within a couple of weeks, you may get a person who's at a bad point in their life during those weeks and see a sample of their behavior which is not typical of them. And that can create a bias that you really don't want in the thing. Or on the reverse, you can get somebody who may be decompensating in some way, and they can hold it together for 1 or 2 days, but over the course of a couple of months, they're not able to do that. So that would be another legitimate reason for it to go out a little longer. I'll be honest with you, a reason that sometimes reports are delayed is one side isn't paying for it, and there's still money owed, and people don't write reports until the money has been paid in full. So the delays may mount, but a year is extraordinarily long. And I think the Pennsylvania legislature and the Pennsylvania courts have really tried to push to get cases resolved more quickly than that.
Okay.
The other problem you face with that long a report is you go into court and your data's a year old, and somebody says, "Did you know that Johnny now has been kicked out of school?" And so you have stale data. As far as not including stuff, at the very least, someone doing an evaluation should list everything they considered, okay, in the report. They may not then put any weight on it. So you might hand somebody a journal of all your entries since 2008, and they may say, I had a journal from 2008, but I didn't put any weight on it because it was kind of just a one-sided report of what happened. So that's what I can think of in terms of your question.
Okay.
All right, Tina, thank you very much.
Thank you.
The in all deference to Tina, you also sometimes never know when people say, well, they didn't do much or they didn't include the right stuff. Sometimes that means there was an adverse conclusion they weren't happy with.
That's very true.
And I find they keep believing that if only the doctor had listened to this or would look at that, they would change their evaluation.
Yeah, there's a big difference between listening and hearing and agreeing. So.
Well, and I have the pleasure of dating somebody who has advanced psychological training, so I know you guys can make observations very quickly when you talk to somebody, and put together a lot of information that isn't obvious to the untrained eye. I've learned to cross-examine people, so I think sometimes I get a hint when somebody's saying something to me that it isn't consistent with something that they told me before. It doesn't quite ring true.
Sure.
And that's a skill that I've learned in the courtroom. But I know from dealing with the psychologists like yourself, professionally and personally, that you guys have a very different sense of perception of people's demeanor and why they're doing what they're doing, or at least possible reasons why they're doing what they're doing. And you talked about, for instance, like decompensating and holding it together for a while. And we've seen that. I actually saw that in a custody case not too long ago where the person held it together for, almost the entire hearing, but not the entire hearing.
Right. And that can happen. That's very, very true. I mean, the other thing that happens is not an issue with the custody evaluation, but I can get a custody evaluation in 3 months, but then they don't go to court for a year after that.
Right.
So then your data is stale, but not because you didn't get the report out in time, but because there were continuances and delays in the court proceeding.
There's a theory out there called case management, which sometimes works and sometimes doesn't. But I think if the lawyer's doing it right and the court's doing it right, you get these situations where sometimes the court says, we won't schedule a hearing until we have a report.
Right.
And you want to say, Judge, can you hold with me a little longer? Or you're done for the hour?
Me?
Yeah.
Oh, no, I can stay a little bit longer.
Yeah, hold over to the second hour here, because I really think people want to hear this. We're getting a lot of feedback. Even though we're not getting a ton of calls, we're getting a lot of feedback.
Okay.
All right, hold on.
All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon again, guys. Karl Rominger here, 540-0580, the talk line number. And if you were with us the first hour, we have Dr. Arnold Sheinvold, Ph.D. in psychology, talking with us about child custody issues and child custody evaluations and co-parenting coordinating and all the other things that intersect with the court system and custody cases. And the doctor was good enough to give us an hour and then stick with us a little bit longer. So thank you, doctor.
You're welcome.
I think we were talking about, and I'm trying to remember exactly where we were, but the concept of the co-parenting coordinator and the things you can learn from the report, and talking about when you just talked to somebody who wasn't happy with what was in the report. And I guess I was going to say, and she was unhappy about how long it had taken. So
right.
The setup being is, I was just saying when they so rudely interrupted us with a commercial break that I guess we have to have those, that sometimes the problem is case management. And so you say to a judge, I want to have a hearing. And the judge says, well, I'm not going to schedule the hearing until the report's done. And then the judge gives you a hearing that's 4 or 5 months out. And then this creates this staleness issue in the results that you've created.
Right.
I think sometimes it takes a lawyer to remind the judge, and sometimes in a written motion, hey, judge, we like that plan, but why don't we do this? Why don't we wait? Why don't we get the process started? And as long as everybody's paid their deposit and we get confirmation from the doctor that the process has started, you pick a date and put it on your calendar. And then about a month ahead of that, we'll make sure the report is either complete or will be complete. And if it isn't, then we'll move that date. And I think an aggressive lawyer can help manage that a little bit when you do have a judge or a court administrator who isn't sensitive to that issue.
It also, and actually in support of that somewhat, and I don't want to shoot myself in the foot here, but It also puts pressure on the evaluator to make sure they stay on top of it and get it done in a timely way.
Let me ask it this way. I'm a professional. This is what happens. I come in the morning. I look at my deadlines. And they've got to be done first.
Right.
And then we can get to the stuff that isn't deadlined. And so the joke is somebody said, why do you lawyers always do everything at the last minute? And we're like, well, because that's when it has to be done.
Right. And we're working in a system that is a very clogged and busy system. And every day, resources within that system become less because of budgetary concerns.
Right.
And so there's really a combination of factors that create some of these problems.
I also have and this kind of goes to the theory of, where should we really be investing? And unfortunately, the court system seems to invest a lot of its time. Everybody thinks that the court system is clogged with personal injury cases. And it really isn't. It's clogged mainly with criminal cases, family law cases, and business-to-business litigation. Mm-hmm. Can't do anything about the criminal case. I mean, we have to deal with those. But taking resources away from the family law arena is, in my mind, not a good long-term solution, because I think if the courts are creative and we get involved and we intervene a little bit in some of the high-conflict cases, we can probably prevent kids from growing up who have worse outcomes. And I think, you correct me if I'm wrong here, but a child whose parents cannot get along in a split custody situation and who cause grief for the child probably hurt their development in a way that causes higher likelihood of criminal behavior, less employability, more long-term psychological impairment, etc.
One of the most robust findings in the research on children of divorce is that children who are exposed on a consistent basis to the interparental conflict, and especially if it includes physical conflict, have more problems with depression, what's called internalizing and externalizing problems. Internalizing problems are worry, anxiety, depression. Externalizing problems are acting out, aggression, drug abuse, alcohol abuse, sexually acting out, teenage pregnancies, those things, academic failure. So that is, if there's no other finding you want to believe in the research, that's been replicated hundreds of times, that the interparental conflict and hostility, the more open it is and the more severe it is, the worse the results for the kids. So when we talk about the very high conflict cases, those are the kids who are most vulnerable. The other interesting comment on society, and I'll make it, but
Right.
Don't want to get lost in it, is that we tend to invest more money in business litigation. The court's taking time for business litigation and criminal court than for families and kids. And there's just something fundamentally wrong about that with respect to value.
Well, and it's interesting you point that out. So you say, you're talking about how hard it is to get a custody case that's more than a day. In Franklin County, Pennsylvania, they've been pretty good about giving multiple days, although these days their court calendar has really been crunched with criminal stuff. And of course, now they've even kind of rolled back, I think, their willingness to do 3- and 4-day custody trials if the parties ask. Mm-hmm. But in the meantime, you can come in on a medical malpractice claim where, somebody's fighting over, a couple $100,000 in damages for something that's already happened. And they tell the judge they need 3 weeks to try it, and the court says, sure. And then you come in with a murder case, and you say, we need 2 weeks to try it, and the court says, can't you get it done in a week? And then you come in with a child custody case, and the judge gives you a day, but then informs you on the day of trial that he's decided that he can only hear the case until 1:30 in the afternoon, so just call your 3 best witnesses. Mm-hmm. Not good.
I totally agree with that. But that's, of course, also then why judges rely more on the custody evaluator. Right.
Which is why, again, and of course, this comes to that next cost, next problem, which is we don't really have a system for people who don't have money to access this system very, very easily.
There's a lot of discussion about a 2-tiered legal system in the United States, and for the haves and the have-nots. And there are many states that have court-connected services. And court-connected services mean there's an evaluator in the court, or there's a mediator in the court, or there's a parenting coordinator in the court, who is a court employee. Mm-hmm. There are a couple of venues in Pennsylvania that have some of those services, but for the most part, the state does not have court-connected services or court-annexed services. That would certainly help with that problem. We don't have that. And so we all have an obligation to think about how how to solve it.
Right. Now, let me see. We'll take a couple callers here. Joe, you're on with Karl Rominger and Dr. Sheinvold. Joe.
Yes, this is Joe. Thank you for taking my question. I might be veering a little bit away from the topic, but I'll ask my question, listen for the answer to the doctor. I was just wondering what the requirements are to become a coordinator or evaluator and what the demand in the field was. Thank you.
Okay. To be you're talking about two different things there. Generally, there are requirements within the profession itself that may be expected. But the truth of the matter is the court defines who an expert is when you come to a forensic case, not necessarily the profession. So there are certain model standards out there. So, for example, the Association of Family and Conciliation Courts has model standards and includes the areas of specialization that a person should have who's doing a custody evaluation. So they should know family dynamics, they should know how to utilize psychological evaluations, psychological testing, they should have expertise in interviewing children and adults, they should have an understanding of how psychopathology affects parenting, those type of things. With respect to parenting coordination, there are guidelines that have been put out by both the American Psychological Association and the Association of Family and Conciliation Courts. And within those guidelines, they are saying that a PC should have at least a master's degree in mental health field and or a JD. Although parenting coordinators can certainly be community volunteers. But then it's a matter of having the training necessary, and they should have training in mediation process and mediation skills, and then all those things I talked about with respect to the specialty areas for child custody evaluators. They should also have an understanding of those things, and finally have an understanding of arbitration procedures, since they'll be decision makers as well. I don't want to go into a whole long explanation of competencies, but I would say that's it. There is no specific specialization of child custody within the profession. You generally might specialize in forensics and then get specialized training beyond that.
Interesting. So what we're going to go to break. Doctor, can you hold us a little longer? I mean, I'll take you all the way to 3:00, but you probably have stuff you want to do.
I really I had only thought I was going to be an hour, so I need to leave here by about 25 after 2.
Okay. Yeah. As soon as you need to go, just jump. I know a few more callers. I'm going to take a quick break and then we'll take them.
Okay.
Hey, guys, talk line here is 540-0580. But if you need to get hold of the doctor, and if you think you need some kind of psychological services particularly, and it's a comprehensive practice, but we've been talking about the child custody and family therapies, 540-1313. That's the right number, right, doctor?
That is the right number.
Yeah, 540-1313. And I also just put a link to his website up on my Facebook page, so you guys will be able to find it there as well. Doctor, I want to let you know, besides all the calls, we've been getting a ton of Facebook traffic, people just saying how interesting this is, and so you're a big hit.
Well, thank you.
Denise, you're on the air. Denise.
Hi. Sorry, I didn't hear you. My daughter is in a bad situation. Her husband's very emotionally abusive. They have a 5-month-old little boy. She wants to leave the situation, but the husband said he will definitely go for joint custody. Now, she has gone to work, and he has called. He watches the baby when she goes to work. He has called cursing and swearing. The baby's crying, and she's had to leave work, come home. We have all this documented. And she went to the movies the other night with a girlfriend. He's cursing and swearing, saying she needs to come home. He can't take it.
Well, let me stop you for a second.
Mm-hmm.
I always love when people say they don't want to leave because he's going to go for custody. Well, right now he's got joint custody, right?
Well, yeah.
So it's not going to get any worse if she leaves in that strictest respect.
Well, she's afraid that he has never kept the baby overnight. I mean, he will not do anything with the baby as long as she's there. And he's never given it a bath. He's never given it baby food. He's never done anything other than give it a bottle and change a diaper.
Right.
So she's scared to death that if she leaves and it goes into a custody thing, that he will have the baby regular custody time, and not be what she feels, a fit father. So we did see a lawyer. We had all this documented. The lawyer didn't even want to look at the document. She says if he pushes joint custody, they will give him joint custody, and the best you can hope for is that they will send him to parenting classes, say he's a new dad. And she said, well, he says he hates his life, he wants to die, and they said, well, they'll just put him on antidepressants, say he's depressed. I mean, everything she thought she had seemed to close doors on her. So she feels kind of stuck. She doesn't want to share time with a father that really shows only interest minimum in the baby.
But that's and I'm going to answer for the doctor, I think. Didn't you tell me earlier, doctor, that one of the studies shows that upon separation, a lot of the dads get better at it?
Well, dads do get better. The studies do show that. Part of my answer to this question would be, number one, it might depend what jurisdiction you're in as to what judges or conciliators might do in the situation. But in Pennsylvania, there is no presumption of joint custody, meaning that there is no understanding that when you go in the court, it'll automatically be joint custody. Meaning
so the judge
equal custody.
or the lawyer pretty much made us sound that way. That and the baby's breastfed, and the lawyer said that they will tell my daughter to wean the baby so that he can have custody.
Well, it depends what you mean by joint custody, and oftentimes what happens is there's a confusion of terms. If you mean will the dad be able to get some overnight time with the child, but maybe not equal to the mom? And if you consider that joint custody, then, yeah, there's a good chance of that. There's a lot of debate out there about whether young children should have overnights away from the primary parent. But I will tell you, the research is very ambivalent and very uncertain as to whether that's good or bad. There's research that says it can create insecurity in the kids, and then there's research that says it doesn't do that at all. And if we look at real-life situations, it's not uncommon for 5-month-olds to spend an overnight with a grandparent, for example, while the parents go away for the weekend. So it's not that kids can't be away from their parents at all. I think the situation would need to be evaluated on the factors you've mentioned. So is somebody verbally abusive? Are they so unskilled at this point they need some parent education prior to getting to the point of overnights? And you need an evaluation of that. You wouldn't be able to just make that assumption based on what's called he said, she said evidence.
And Denise, I'll also tell you that having done many custody cases over the years, I sometimes find that no mother wants to part with their baby under any circumstance, even in a intact relationship. The first time they leave the baby with the grandparents overnight, they're freaking out. So you kind of have to sort out what's real and what's imagined, and also recognize that if the guy does step up to the plate, the courts are probably going to let him attempt it. But exactly how that'll play out, I don't know. I'm going to let you go because I want to take one more caller before the doctor has to go here.
Okay,
thanks.
You.
And Lisa, you're on with Dr. Sheinvold.
Hi. My question was actually, I wanted to know how old a child needs to be for any form of psychological evaluation or meetings to actually be effective or useful.
Depends what you're evaluating. If you're actually evaluating the parent's competency, you could have a 4-day-old infant, and you're trying to decide if a parent has the skills or ability to care for a 4-day-old. And maybe the parents need some parent education around how attachment is developed and how you maximize the ability of the child to attach to parents who aren't living together. But if you're asking how old does a child need to be evaluated for their own psychological health, there are individuals who do specialized infant evaluations looking for developmental aspects in their behavior that they can begin to assess what's happening in terms of cognitive development or social development and whether there are delays in that.
Okay. As I have a 4-year-old and a 1.5-year-old, both boys, they live primarily with me, but they only go to their fathers generally on the weekends, which they do spend overnights over there, sometimes 2 nights in a row. there's no actual custody arrangement, so everything is just the way we decide right now, mostly how I decide. But I've noticed serious reactions from both children when they come home sometimes, and I've been really concerned about how well they're being taken care of over there. I know for one thing that the diapers are not being changed well, because I send a child over for 8 hours with no diaper rash, and they come back consistently with one. That much I know is at least going on. But this last time, something was very wrong. He was clinging to me like he's never done in his entire life. He
being which one?
Terrified to get in the crib, the 1.5-year-old.
Well,
and he, of course, can't tell me what's happening, and his brother isn't really quite to the point where he can fully explain to me what's going on either.
Remember that children go through normal developmental stages, so that a child who at, let's say, 13 months old was not showing much reaction, at 18 months old might be showing reaction because they're going through kind of a second stage of separation anxiety.
Okay.
And so you have to sort out that which is normally developmental, along with the fact that all people, and children in particular, get moody around transitions, and these are transitions the kids have to make. So I think it might be helpful as a starting spot for you to talk to your pediatrician about normal kind of developmental stages like that, and see if some of it can be attributed to that. I mean, diaper rash can't be attributed to that, but certainly some of the transitional aspects of mood could be.
Okay.
Okay?
Yeah, I was so concerned this past weekend that it made me start wondering about it.
So Lisa, I think you should follow through with that and see where it goes. And then if the concerns continue, then you might want to, take it to the next step. But I would work with the pediatrician.
Okay. All right. Thank you.
Doctor, I know you got to go, so I want to thank you so much for coming on and helping us. People are very, very interested in this topic.
Well, it was very much my pleasure. If there's another time to do it, we'll do it another time.
Yeah, we definitely would love to have you back. There's no doubt about that. I can tell you that the call volume has just continued to build. Like I said, we're getting tons of feedback. People are this is one of these areas where, it's kind of, there's a mystique to it. People go to custody court, and lawyer and the psychologist and the judge are kind of, chopping everything up and then telling them what to do. And I don't think a lot of times they understand why the court does what it does. Now, hopefully, they have a better understanding of why you as the custody evaluator do what you do.
I hope so. Hope it helped.
All right. Well, thank you very much. Again, if people want to get in touch with you, it's 540-1313 to get to your practice. And basically, you guys can help people with all different sorts of issues involving family law.
There are 12 different therapists and different professional backgrounds up here.
And I do have a link to your website up on our Facebook, and we're going to put it up on the other show websites. So hopefully people will follow up. And if you do go see the doctor, make sure you let him know you found him here on the radio so he knows it was worth his time. Definitely worth ours.
Worth my time one way or the other. So thanks.
Thank you, doctor.
You're welcome. Okay, bye-bye.
Bye-bye. Yeah, you can't beat that, guys. I mean, you get a real live expert like that who does this, who parses these things to help us out. I wish more of you had been able to catch him on the phone. Rob Culling, how are you?
Pretty good. How's it going, Carl?
Good. Were you able to catch any of the doctor?
A little bit, yeah. Very interesting and very, very important for folks to know when they have custody questions about, especially about custody evaluations, risk assessments, mental health evaluations. It's very important for these folks to know this going into it, what they can expect and what they think they might need.
Yeah, and I think we only touched the tip of the iceberg. It felt like we filled up an hour and a half, and half an hour of it might have been with callers, but an hour of it was just discussing in general the process, and I don't feel like we even got that specific. That's how much stuff there is out there in this area and how complex it really is. But I think the doctor did a good job of helping people understand that, and I thought this was very fascinating. Basically, you're going to get 40 hours worth of court time packed into an evaluation that you'd otherwise have to do 7 days of hearings to get the equivalent in front of the judge. And so, and people go, oh my gosh, that report's going to cost $3,000 or $5,000. Well, guess what? 7 days of a lawyer in court. Let's just assume that the lawyer is going to bill $150 an hour, 8 hours a day, not going to do any prep or anything else for the case, right? And we're already at what is that? $1,200 a day times 7, blah, 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 blah. $8,400.
Mm-hmm.
Then if we add on the prep time, et cetera, we're going to end up with a $15,000 bill most likely.
Right.
So all this only $5,000 is one-third the cost, and quite frankly, you're getting an expert, not just a knucklehead lawyer, putting all this stuff together.
Right.
Rob, can you hold with me for a little bit?
Sure.
Guys, if you don't know Rob Culling, he practices in my office, and Rob actually does a general practice. He does some adoption, some family law, some custody work, as well as a host of other things. But he's going to hang with us and answer questions for the next half hour. See you after the break. Hey, welcome back. Karl Rominger here. Well, we were doing the custody show, and now we'll just keep taking legal questions for the next half hour or so. I'm joined here by Robert Culling in my law office. If you ever call in and you can't get me, Rob is also available, and that's part of the reason I like to bring him and the other lawyers on the show so you folks can talk to them. I would obviously not hire somebody unless I was willing to let them represent me. Let's see. Who's our next question here? Megan, you have a question?
Good afternoon.
Yes.
Hi. I just had a comment basically in response to the last lady who called. I believe in fair custody. Men can be just as good as parents as women. But I was through this 20 years ago with my children with a very abusive in every way spouse.
Mm-hmm.
And no one wanted to listen to what my children had to say. The children underneath people brushed it under the rug. They refused to deal with it. And we were ordered to go through this court-ordered evaluation thing. And I'm not passing judgment on any professional, but I'm telling you, it was just a nightmare, and my children suffered so terribly because no one wanted to listen to what was really going on and their suffering. And I guess I would just encourage. It just really made me angry. Of course, every time your child, cries or has a nightmare, you don't say, "Oh, I'm going to blame it on the ex because they were,
Right.
just visiting." But you've got, whether you're a mom or a dad, when something out of the ordinary, uncharacteristic happens with your kids, you've got to listen to your gut, and we've got to protect our children.
I don't disagree with you, and I go back to the diaper rash for a second. I'm thinking. If you really do religiously change diapers, you very rarely get a diaper rash, for instance.
True.
So the mere happening of one alone doesn't mean somebody's a bad caregiver. But if it's chronic, it's either and if it's only happening in one household, then I think it's pretty self-explanatory. I know everybody has different standards. Some people use the same bath towel for a week, and some people use a fresh towel every day. And I'm still using the same towel that I had in my dorm room in college. The long and short of it is everybody has different standards. So I can see differences there, but there are minimum cares. Now, when you talk about potential physical abuse or psychological abuse of a child, and you're not there to observe it, and then again, kids don't articulate these things well. They're afraid to tell the other parent. They have crossed loyalties. There are so many issues involved in that. And but then the flip side is, as often as there is something legitimate going on, when we get into these subset of high conflict parents, that 10 to 15% we were talking about, we get frustrated in the court system because they will find everything to be some symptom of unknown abuse that nobody else will recognize. And if only we would listen, we would know about, and we could, they could prove it, but just nobody will listen. And so, unfortunately, those people do as much harm to everybody else as they do to their own families. Because it causes judges and lawyers and sometimes maybe even psychologists to become a little more skeptical than they should be when something legitimate is going on.
Right.
And
right.
So it's so complex. There's so many moving parts, but your comment is very well placed. It's
just got to be from our courts to everybody. They just need to drop the political BS that goes on. I come from a small county, so it was that kind of mentality, and I bucked the system. And over my dead body, were my kids was it going to continue? And it's just any good parent is that way. And so I would just encourage. Well, I'm not downing anybody or anybody's profession. Just your children, and if they're not safe If you're not going to stand up for them, who will? And we as a society need to say, that kind of behavior and mistreating children, it's wrong, and there are consequences for it.
All right, Megan, appreciate it.
Thank you, Carl.
Thank you. 540-0580. Stephanie, you're on with Carl and Rob.
Hello?
Hello.
Hi, yes. I have a question for you. I started working at a hospital in 2008, and one of the things that they offered was a scholarship program for the nursing school I was going to. And it was very attractive. It said, we will pay, and then you have to pay us back by 1 month's service for every month of the scholarship that we provide for you. And they provided 8 months for me. So I graduated from school, and they kind of put me off for a little bit for a job, played around a little bit. I waited a year, and then they put me into a nursing position.
Okay.
It's an odd situation, but at any rate, I was actually let go. That was the phrase they kept using, let go. And so I went out and I searched for other jobs, and I applied for unemployment. I was granted unemployment because it had been an extremely hostile work environment, and it was determined by labor and industry that I had done the best I could. I was always there on time, etc. Well, I just got a letter from them. They contested my unemployment, and then when labor and industry decided that I did earn the unemployment, they sent me a letter from the hospital.
Right.
And I believe it's punitive, and it says, oh, hey, you only worked for 5 of the 8 months that you owed us. Now you have to come up with $4,700 and some in 30 days.
So they're trying to get money back.
Exactly. Now, the terms of the contract I signed address things like, you have to do the job, you have to, maintain your standards and everything. The one item they do not address is involuntary termination.
Yeah, so what we'd have to do is read the contract very specifically, and then determine what our best position is in terms of what it really says and whether you actually owe the money back or not. And that's what happens. They'll take a position, you'll take a position, and maybe either side will persuade the other one to blink, maybe settle it, or ultimately have a court resolve it. But that kind of contract interpretation that you're asking for would require us to actually sit down and read the contract.
That's fine.
So why don't, if you want to call our office, it's 241-6070, 241-6070. You could ask for Rob Culling.
241-6070.
Yep, Rob's been listening in, so he'll be familiar with it when you call.
Absolutely.
And he can read that over and try to come up with an interpretation. Listen, notice I say interpretation, right? It reminds me I had a client who wrote a contract in Chinese with another Chinese speaker. And, of course, when they both translated it, they both came up with one word different. Right. And it was the word that made all the difference, right?
Right.
The other lawyer and I are kind of looking at each other like, well, who knows, right? We'll have to get an official translator to tell us. And, of course, then we found out that word could mean both those words in English. Yeah. So it was even worse, right? So then you really got to try to figure out what was going on. But my point is everybody can take a position on what they mean in a contract. The court starts with the plain language and works backwards from there. But we have rules on how to do that. All right?
Okay.
Hey.
So what should I wait till Monday to call?
You can call Monday's fine. Yeah.
Okay.
All right. Thank you.
Great. Thank you so much.
Not a problem. 540-0580. John.
Did you say John?
Yes.
All right. Good afternoon. Love you guys' shows. I can't wait for it to go to 3 hours. Here's my question. 7 years ago, approximately, I had a full septic system put in. Recently discovered that what it looks like is one of my pumps down at my sand mound is dead. I had multiple plumbers come in and contractors, septic people, etc., and there was a reoccurring theme with some of the ones that had been around a little longer, and they pointed to the fact that what wire size had been run out to my pump. They started talking about voltage drop over length of wires, etc., and how it can be bad for pumps, and basically it will destroy even the best of pumps over time. Now, I know that the National Electric Code has recommendations. They have fine notes, as they call it, but it clearly says in one of the sections of electrical code, which I've been looking up, requires equipment to be installed in accordance with the equipment instructions. Therefore, electrical equipment must be installed so that it operates within its voltage rating as specified by the manufacturer. It's clear. You can do the online calculators. You can follow Ohm's law. It's nowhere near what it should have been, probably leading to my pump failure, leading to a new $800 pump, the digging, the sand mound being clogged, etc.
So,
do I have any recourse?
You can sue. Now, how long ago was this installed?
7 years.
7 years. So what we'd have to look at is you just realized the problem. So it's from the time you realize the problem that matters. But then we have what's called the statute of repose, which says you still have to bring a claim for some kinds of construction and other things within a certain time period, no matter what. Not sure what the statute of repose is on that. What I would recommend you do, again, if you want to call in the office and check with Rob, we can probably do a little preliminary research for you. It costs you a couple $100 and give you an idea. But basically, I think you would have a lawsuit at this point. The real question is then the person you would sue, do they have assets that you can collect?
Well, they own an excavating company.
Right. Well, that's point one. But how about this? How about they own an excavating company, but they're married, and all their equipment is leased to the excavating company by the marriage, and their home and all their other assets are marital, and then you can only reach the excavator, and he doesn't have any assets.
Kind of like signing a tenant agreement with a landlord, but everything's in both their names, so when he does you over, you can't go after anything.
Yeah, you've been there.
Yes.
So, on the other hand, though, all the best laid plans sometimes end in divorce, and then everything gets split up between the contractor and his ex-wife, and then he's not judgment-proof anymore. So, a lot to look into there, okay?
It's fair enough. It's enough for me to consider more than.
But you definitely have some.
How to get a hold of you guys?
241-6070, 241-6070, or go to romingerlaw.com.
Already there.
I got to go break, guys. We'll be back. All right, welcome back, kids. Now, first of all, I got a text here I'm supposed to read to you. One of my friends/clients said, I was going to call and thank you for helping my case and to tell people you're the real deal, but I'm a bit shy on the radio. We'll read my text. Thank you. You wanted me to read on the air. So, yes, I did get your text, and I really appreciate it, and I do the best I can, which is sometimes means I lose, but it is a good effort anyhow. 540-0580. I also want to give a special shout-out to my girlfriend, Hillary, and just say what a special woman she is. I talked about her a little bit in the first hour, so I just owe her that, I'm sure. But she's a lot smarter than I am. So anyhow, Kevin, you're on the air. Kevin.
Oh, hello. Oh, I'm sorry, Carl. I didn't realize you were talking to me.
Yeah,
thanks. I hope you can help us with our problem.
Yes.
We have grandchildren with my wife's son's family. And due to just a nasty attitude and behavior, we've been cut out of their lives. And before, my wife spent a great deal of time with them, and she just decided that she wasn't happy with it anymore. Not my wife, the daughter-in-law. So I'm wondering what kind of rights we may have as grandparents to be able to see our grandchildren.
Well, Robert, I don't know what you listen to this and tell me whether I'm right or wrong here.
Okay.
I would think that the children are an intact family. In other words, it's the in-law and the child. Yep. And so you're not going to be able to activate any of the grandparents' issues where, one of the parents is dead or one's a drug dealer and in jail, one of those issues. Now, the next question is, did the grandchildren ever spend any amount of time living with you?
No.
Okay, so you're not going to be able to get under the other subsection that says, that where a child's lived for more than a year in the grandparent's house, with or without the parent, there's an automatic right of visitation, not custody, but visitation. So, Rob, did you see any other standing for them?
With that scenario, I'm not really sure. That it doesn't seem like there's a position where they could take as if they were acting as a parent. Like you said, there's no risk of harm to the kids. The kids don't live with them. I mean, especially with the new laws here in Pennsylvania, there's a significant hurdle for parents.
Grandparents.
Sorry about that. Yeah, and so they might be in a position here where
now
they might be deadlocked, but that doesn't mean they can't come in. I can go over every factor with them talk to them about it, see what, maybe there's something that we can do.
And the other thing is, I call it the bluff, but sometimes even if you don't have any standing at all,
right,
you write a letter and you say, hey, I'm taking you to court,
right,
and I'm going to try, and here's my thin angle that I'm going to argue that I'm making, and the other side goes, well, and then the other problem is you may be having a problem where your son, for instance, may not really realize what's going on.
Yeah, he's very well aware of it, but he's not willing to give up his standing in the house to go against her.
So maybe he needs some leverage. Listen, honey, I understand you don't really want to do this, and I'm not really not backing you. I'm just pointing out that it's going to be very expensive for us to fight this. Or, you may give him some leverage to help reverse the dynamic. So that might be how the threat of a legal proceeding could change the dynamic.
Yes, I believe you're right. If we went against her, it's not going to help us to use him as a lever.
No, but
he's backing out of the situation.
But it may cause him to go, wait a minute, my parents are actually suing me for custody. What's going on?
Yes.
Yeah.
I see what you mean.
The other fact is that you actually have to sue your son as well as the
you can't. Yeah, for court action, you got to go against both of them because everybody with a right to the child would have to be noticed.
Correct. So we would contact you at KarlRominger.com?
Yeah, just go to RomingerLaw.com.
RomingerLaw.com,
Yep.
okay.
All right, and then Rob's familiar with the case, so he'd probably be happy to help you.
Absolutely.
Okay, very good.
All right, take care.
All right, thank you very much.
Not a problem. 540-0580. Tony.
Hi, Carl. How are you?
What's going on?
Good. Hey, I have a lady who sued me with a civil suit about 6 years ago. I sold her a house that I owned for about 1 year, and I never had water in the basement. Sold it to her. She got water in her basement, so she sued me, I think, in 06. It could have been 07. Well, I filed a claim with my insurance company, and we went through, a long time of debating and stuff, and it finally was settled that they do not have to cover that under the liability section of my homeowners. And it's been forever since they've done anything. So my question is, how long can someone drag out a civil suit like that? Now, we did do all the depositions. We did all the discovery.
Right.
We did all the fact findings and whatever else is out there. So how long can they drag that out?
Well, if it's been sitting forever, basically, as long as both sides are, Jarndyce v. Jarndyce. But the question is here, why don't you go back to the court and say, I want my trial, okay? But you may not be in a rush for that. Or you can go to the court and say, hey, they haven't done anything in X number of years. I think you should dismiss this lawsuit for inactivity. But the danger of doing that is called sleeping dogs. Sometimes when you kick them, not only do they not run away, but they turn around and bite you. So, those are your...
one option. So one option is to ask the court to...
You file a motion and say, I'm ready for trial, Judge.
Yeah. And then the other...
The other side's got to answer it.
Yeah. And the other option sounds pretty similar, and that is to...
File a motion that says...
Just tell the court that says ask them to speed things up?
Well, in the second motion, you say to the court, I want the lawsuit against me dismissed for failure of the other side to prosecute it forward in a timely fashion.
Okay.
There used to be a case called pen piping years ago. When they used to say you got piped, there was a per se 2-year inactivity rule. And what happened, though, was it got to be a whole fight over what was significant docket activity or not, and the Supreme Court eventually withdrew the per se rule. But we still have a rule that allows for you to basically allege a non-prosecution of a case and get it dismissed. And it has to be over with the passage of time and prejudice. But so that would be the smarter of the two to file because you're the defendant, right? You file that rather than I'm ready for trial. If you lose it, then you say I'm ready for trial.
Okay. I think I am because I think it's a strong case. And, of course, we always think we have our own strong case. And, of course, the other party thinks that too. But it seems like a pretty easy decision. I don't know. But it was just a very eye-opening thing to me. I've never been sued in my life, and I never dreamed of being sued in my lifetime. But I want the listeners to know that someone does sue you. Be prepared to last about 10 years for a civil suit. I couldn't believe it.
I know. Got to let you go, brother. Hey, guys, we'll be back next week, 1 to 3, answering your legal questions. It'll be Easter weekend, so enjoy preparing for the holiday. It's time to do those little Easter egg hunts. Might get some trout fishing in today. Did some shooting with Steve Snyder in the office earlier. Take care, guys. See you next week.